There is a question sitting at the center of American constitutional law right now that no court has fully answered. Not the Supreme Court, not any appellate court, not any district court. The question is this: does presidential immunity end at the courthouse door, or does it follow a president into civil litigation, into jury verdicts, and into judgments worth tens of millions of dollars? That question is about to land in front of 9 justices. And what makes it genuinely consequential is that the last time the Supreme Court addressed presidential immunity, in July 2024, they answered a different version of it, and the answer they gave made this new version more urgent, not less. Let me walk you through the actual legal architecture, because the 3 active fronts where immunity is being litigated right now are each testing a different edge of the same boundary. Start with what the 2024 ruling actually said. In Trump versus United States, a 6-3 majority authored by Chief Justice Roberts held that presidents have absolute immunity from criminal prosecution for core constitutional acts and presumptive immunity for all other official acts. The decision was written, as Justice Gorsuch noted from the bench, for the ages. It was not written for one president or one case. It was written as a permanent framework for how presidential accountability works in America. What the ruling did not answer, and the majority was deliberate about this, is where official acts end and unofficial ones begin. That line was sent back to the lower courts to draw. Judge Tanya Chutkan received the January 6th election interference case on remand. She was supposed to conduct an evidentiary hearing to determine which of the specific acts in Jack Smith's indictment fell inside or outside the immunity boundary. As of May 2026, a legal analyst on MSNBC with direct knowledge of the case described the federal election interference proceeding as basically dead in the water. The DOJ under the current administration dismissed the case before Chutkan could finish the immunity analysis. The question she was supposed to answer is now unanswered. It is in a closed case file. But the immunity ruling's impact did not die with that case. On March 31, 2026, U.S. District Judge Mehta issued a 79-page ruling in consolidated civil lawsuits brought by Capitol police officers and members of Congress. He ruled that Trump's speech at the Ellipse on January 6th fell outside the outer perimeter of his official presidential duties. The ruling cleared those civil cases to proceed to discovery and potential jury trials. Trump is not immune, Mehta ruled, from civil liability for his affirmative conduct that day. That ruling is the first significant post-2024 decision drawing the immunity line in a specific place. It says a presidential speech to supporters outside the Capitol, urging them to march to the building, is not a core constitutional act. It is not official, and therefore it is not protected. That ruling is now on appeal. Then there is the Carroll case. As of May 6, 2026, Trump's legal team filed with the Second Circuit to bring an immunity claim to the Supreme Court in the defamation case. His attorneys laid out 2 specific questions they intend to ask the justices. First, whether a president's absolute immunity from civil claims based on official acts can be waived at all. Second, the Westfall Act question, whether the DOJ's attempt to substitute the federal government as defendant was timely and valid. The Department of Justice filed its own separate petition on the same day, supporting Trump's position and stating its intent to bring the Westfall Act question to the court as well. Think carefully about what that filing represents. The sitting president's Department of Justice is arguing to the Supreme Court that statements made from an official presidential platform about a private citizen, statements 2 separate juries found defamatory and made with actual malice, may constitute official acts entitled to presidential immunity. If the court accepts that argument, the $83.3 million Carroll verdict could be erased. Carroll would collect nothing. And the legal principle established would be that a president can publicly attack a private citizen from an official podium and be constitutionally immune from the civil consequences. The Supreme Court has not yet indicated whether it will take either Carroll petition. It takes 4 justices to grant review. The court is not on a deadline. Carroll cannot collect $1 of the judgment while either petition is pending. Now here is what all 3 of those fronts have in common. Every one of them is testing the same question the 2024 ruling deliberately left open. Where does official conduct end? The majority in Trump versus United States said drawing that line was for lower courts to determine. Lower courts have now started drawing it. Judge Mehta drew it at the Ellipse speech and said it falls outside. Trump's lawyers are asking the Supreme Court to draw it around defamatory statements made from a presidential podium and say it falls inside. Those two lines cannot both be right. At some point, the Supreme Court will have to reconcile them. That moment has not arrived yet. The Carroll petitions are pending. The civil January 6th cases are on appeal. The Chutkin case is closed. The immunity question that the 2024 ruling created is being litigated simultaneously on multiple tracks, producing potentially conflicting answers. The one thing the 2024 ruling did not do is settle the question. It expanded immunity for criminal prosecution explicitly. It left the civil question open explicitly. And as of this week, the president's own Justice Department is standing at the steps of the Supreme Court arguing that the expansion should reach further still. The question the justices wrote for the ages is not finished being answered. The lower courts are still drawing the line, and the line is not in the same place on every map. There is one structural detail that has received almost no coverage in the mainstream analysis of this story. The 2024 immunity ruling was written by Chief Justice Roberts. Roberts authored the opinion that expanded presidential immunity to its broadest scope in American history. Roberts is also the same Chief Justice who, in a different context earlier this year, said publicly that personal attacks on the judiciary come from more than one political direction and that judicial independence is not negotiable. Those two facts sit in tension. The court that expanded presidential immunity is simultaneously the court whose Chief Justice is defending judicial independence against political pressure. The Carroll immunity petition is heading toward that court. The January 6th civil immunity appeal is heading toward that court. The question of whether the executive branch can use the DOJ to absorb a sitting president's personal civil judgment is heading toward that court. Roberts wrote the opinion that made all three of those questions possible. He may also be the fifth vote, or the deciding voice, when the court is asked to answer how far his own ruling actually reaches. The 2024 decision was written for the ages. The ages are still in progress, and the cases that will define where the immunity line actually sits are working their way up through a judicial system that the Chief Justice has publicly insisted must remain independent of political pressure. Whether those two things can coexist, a sweeping immunity ruling and an independent judiciary willing to enforce its limits, is not a question anyone in Washington has answered yet. It is, however, the question that every pending case is quietly asking. The line is still being drawn, and the man who drew the original boundary may have to decide how far it extends.